who is the Associate Assistant Deputy Minister of Strategic Program Policy, and Nicole Girard is the Director General of the Citizenship and Multiculturalism Branch. And I don't know who you are. I have your name. Oh, here it is. Mary Afshar, a lawyer. Good to have you. Thank you. Welcome to the committee. So, Mr. Minister, thank you for coming. You have the usual 10 minutes to make your presentation, and then, of course, the committee will have some questions of you. Thank you, sir.
Merci, Monsieur le Président, chers collègues.
Thank you, Mr. Chairman, dear colleagues. Thank you, as always, for the opportunity offered me today to speak to you about our bill, C-24, an act to amend and reinforce the Citizenship Act.
Since 2006, Canada has enjoyed the highest sustained levels of immigration in our history, an average of 257,000 newcomers per year. And as a consequence of this achievement, demand for citizenship has increased over that time by 30%. Furthermore, Canada continues to have, and by a widening margin now has, the highest rate of naturalization in the world. 85% of eligible permanent residents become citizens. Last year, CIC received more than 330,000 citizenship applications, the highest volume ever in 1 year. So far in 2014, Canada has welcomed more than 75,900 new citizens at 759 ceremonies held across the country in this first quarter of 2014, from school gymnasiums to CIC offices to city halls and hotel conference rooms. This is something of which we can all be very proud. Compared to 2013, we welcomed, still a high number, 35,320. We're well over twice the rate of last year so far in 2014. So we can say with confidence we're off to a great start in offering citizenship to those many who want it and the increasing numbers who qualify for it. These high numbers demonstrate the system is becoming more efficient. The backlog of citizenship applications is decreasing, helping more people realize their dream of becoming Canadian sooner. In the speech from the throne, our government committed to strengthening and protecting the integrity of Canadian citizenship by introducing the first comprehensive reforms to the Act in over a generation. Les modifications comprises dans la loi renforçant la citoyenneté canadienne.
The changes in strengthening Canadian Citizenship Act mean more newcomers will be able to acquire Canadian citizenship faster. These reforms are taking place after decades of neglect by previous governments, and now we are taking action in order to deliver better service to Canadians. Our government is acting to restore the great importance Canadians place in their citizenship and also to deter citizens of convenience.
Reforms fulfill our government's commitment in 4 specific ways. They, first, improve processing efficiency. Second, reinforce the value of citizenship. Third, strengthen integrity. And fourth, protect Canadian interests and honor service. Let me begin by describing some of the improvements in the Act that enhance efficiency. One of the most important changes, as you all know from our debate and from public debate in the House and from public discussion, is that there will be a streamlined approach to citizenship processing that will offer faster and better service standards for applicants. La loi renforçant la citoyenneté modifie le traitement des demandes en ramenant.
The Strengthening Canadian Citizenship Act changes application processing from a 3-step to a single-step process, reducing the current duplication of work and wait times. A common reason for long processing times is incomplete applications. Under the old system, each application received had to be processed regardless of whether or not all the required forms were properly filled out. Now, however, applicants who have delivered complete applications will no longer have to wait behind those who failed to do their due diligence, because incomplete applications will be returned and not processed until all documentation is present in one complete package. Taken together, these and other measures will significantly reduce the backlog and the average processing to less than a year by 2015-2016.
To Canada by ensuring they have a physical presence here. That is why we're lengthening the residence requirement from 3 out of 4 years to 4 out of 6 years before applying for citizenship. This will ensure new citizens are better prepared to participate fully in Canadian life. Citizenship applicants will also be required to file income taxes for 4 years out of the previous 6, if required to do so under the Income Tax Act, and make a commitment upfront that they intend to reside in Canada. Tax-paying Canadians should not be left on the hook for those who have no intention of becoming active members of our communities or living in Canada. We want new citizens to earn their passport and stay to be part of our great Canadian society. Many immigration lawyers, consultants, observers of the system to date agree with us. As Raj Sharma said in a CTV program, quote, "Immigration fraud is rampant, and you did see ghost consultants and unregulated consultants counsel individuals to embellish or exaggerate the time in Canada," unquote. He, like most immigration lawyers, know, quote, "The Canadian passport is an incredibly valuable commodity, and individuals are willing to lie, cheat, and deceive us to obtain that benefit," unquote. Now, obviously, not everyone, but a considerable number that we have had of cases have had to be investigated, looked into, and the measures contained in this bill will help us to ensure that that kind of abuse doesn't arise in the future. Because Canadian citizenship is so valuable, many people are prepared to misrepresent facts to make it appear that they qualify. Several recent RCMP investigations clearly show that the citizenship program was vulnerable to fraud. Our government is putting an end to this abuse. We're cracking down on crooked citizenship consultants by designating a body that regulates them. The current penalty for citizenship fraud, such as misrepresentation, is a maximum fine of $1,000 or 1 year in prison or both. Mr. Chair, this penalty has not increased since 1977. Our government takes this form of fraud very seriously. We won't let crooked consultants or those who misrepresent themselves cheapen our Canadian citizenship. That's why the penalty will rise under the provisions of this bill to $100,000 or 5 years in prison, or both, in the case of an indictable conviction. In addition, our government will streamline the revocation process and bar people whose citizenship was revoked because they obtained it fraudulently from reapplying for citizenship for 10 years. Notre message aux criminels et aux fraudeurs étrangers est clair.
Our message to foreign fraudsters and criminals is clear. Canadian citizenship is not for sale. We will revoke Canadian citizenship from dual citizens who were members of an armed force or an organized armed group engaged in armed conflict against Canada, and to deny citizenship to permanent residents involved in the same actions. Dual citizens and permanent residents convicted of serious offenses such as terrorism, high treason, treason or spying offenses will be denied citizenship. These are serious crimes that will not be tolerated in Canada.
Against armed forces will forfeit their right to hold Canadian citizenship. As a result, they won't continue to enjoy the privilege of calling themselves Canadian citizens. We also expect those who hold Canadian citizenship to obey the law. We will bar individuals charged with or convicted of serious crimes outside Canada or serving a sentence outside Canada from becoming Canadian citizens, as we bar visitors to Canada for these reasons already. This seems like a common sense extension of that principle. The security of Canadians is paramount, and we won't compromise the safety of our country. Our government will also reward those who've served Canada honorably in the Canadian Armed Forces and have a strong connection to Canada by fast-tracking citizenship for permanent residents serving with or individuals on exchange with the Canadian Armed Forces. We'll extend citizenship to more lost Canadians. In 2009, our government restored citizenship to the majority of lost Canadians. Now we're extending it to first-generation children born abroad who, under the old system, were not eligible. Our government will also ensure that children born or adopted outside Canada to serving Crown servants or members of the Canadian Armed Forces are not adversely affected by their parents' service and are able to pass on citizenship to any children they may have or adopt outside Canada. Globalement, Monsieur le Président, les modifications que nous apporterons à la loi sur la tutelle.
Overall, Mr. Chair, our changes to the Citizenship Act will protect the value of citizenship and ensure that new Canadians have a stronger attachment to our country. The changes will safeguard Canadian citizenship against fraud and abuse and ensure that the process to become a citizen of this great country is faster and more efficient for qualified applicants.
Of the world, something all Canadians can be proud of. It's our duty to protect the integrity and strengthen the value of Canadian citizenship. The reforms we're proposing today tackle important issues of integrity. They will deliver better service for Canadians, very much in the spirit of all the reforms we've undertaken across the board to immigration and citizenship programs over the past 8 years. And we will show, by so doing, that the value of Canadian citizenship continues to rise, continues to draw unprecedented numbers of people to this country as visitors, ultimately as immigrants, permanent residents, and to give them that unique opportunity that no other country affords on this scale to become citizens once they show the knowledge, achieve the language abilities, and prove that they can live under our laws in a way that so many new Canadians are proudly able to do. Thank you, Mr. Chair. I'm happy to answer any questions committee members may have, and as always, grateful for the opportunity to be here with you.
And we with you. Mr. Minister, thank you for your presentation and for appearing with us to help us with this bill. Mr. Meningakis will have some questions for you.
Thank you, Mr. Chair, and thank you, Minister, to you and to the officials who are here with us today. We are on day one of starting the study on this very important bill. As you know, Minister, since 2006, Canada has welcomed the highest sustained level of immigration in our country's history. The current Citizenship Act is 37 years old. It certainly needs amendments to reflect the reality today and to certainly to assist us in processing the demand for immigration that this country continues to have, which continues to increase, and that we've been able to sustain since our election as a government in 2006. Minister, in your opening remarks, you stated that C-24 aims to strengthen the value of Canadian citizenship. Can you explain exactly how the bill does this, please?
Sure. Well, one way we aim to do this is by a slightly longer residency requirement. As you know, Mr. Meningakis and other members of the committee know, before 1977 there was a 5-year residency requirement, and indeed for many peer countries it remains so. We went down to 3 years. As I mentioned in the quotation in my opening remarks, it became obvious to many observers that there was abuse even of the 3-year requirement. In other words, people received citizenship, not just a few people, but hundreds, even thousands of investigations are now underway, without actually spending that time here. We have heard from new Canadians, Canadian citizens across the board, that there is no substitute for that direct experience of Canada, and so the residency requirement will go from 3 years to 4 years out of a total of 6. There's still flexibility for those who have global businesses, have global lives, have other parts of their family outside the country, but we expect those 4 years to be fulfilled. And we also expect new Canadians who seek to acquire citizenship to meet basic, predictable knowledge tests of language ability, English and French, or French, ideally both, and knowledge tests about Canada. And the Discover Canada Guide has proven extremely popular. New Canadians who use it are extremely successful in gaining that knowledge and showing it in the exam. We're also strengthening the value of Canadian citizenship by going back to this issue once again of lost Canadians and making sure that we haven't missed any of those who really deserved to have Canadian citizenship from the beginning when the first act was passed in 1947.
Thank you. Minister, demand for citizenship is up, and it's up for a lot of reasons. But as we all know, our Conservative government has welcomed over 1.4 million new citizens since 2006. As Canadians, of course, we're all proud that there's a high demand for Canadian citizenship. Our government recognizes that backlogs and processing times, however, need to be tackled, Minister. How will the changes in Bill C-24 result in faster citizenship processing?
Thank you for that question. First, the bill will give us a new decision-making model. Instead of going through 3 steps, we will go through one decision maker who has all of the data, all of the tools, and indeed exit entry controls starting next year to help validate the residency requirement, will be able to take the decision, and it will go faster. But in addition to that, we are putting more resources. We have put more resources into citizenship processing already in Economic Action Plan 2013. More resources went in. They are at work today, giving us those higher numbers of new citizens in 2014. And I draw the committee members' attention to something we've distributed earlier in English and French, which is a simple graph of what would happen if we did nothing, as some urge, to processing times, and then what is happening with the new resources that we put in through the budget last year, which is a red line And what will happen with the new bill, which is a blue line that will bring down waiting times even faster to 1 year by the end of the fiscal year 2015-16. And this document is called Strengthening Canadian Citizenship, Shortening Processing Times, Renforcer la citoyenneté canadienne, Réduire les délais de traitement.
Shortening processing time and accelerating the
2 minutes.
2 minutes. Well, you held up the graphs, Minister. Can you give us an indication of what it will look like once, what the backlog of applications will look like when the changes to C-24 are made and fully implemented?
By 2015-16, towards the end of that fiscal year, average citizenship processing times will be less than 1 year, and the backlog will be reduced by 80% from what it is today.
Thank you. Perhaps we can get some assistance from the officials here as well. Could the officials tell us, or maybe you, Minister, if you like, other ways that CIC has already modernized the citizenship program to improve service standards and citizenship processing times?
There have been a huge number of changes, including the requirement that people turn up for their tests, turn up for the ceremonies, not have options of being no-shows. We have, yes, given the option to citizenship applicants to retake the test when they don't meet the necessary requirement, but they can't take it over and over again forever. We've also come to grips with the residency requirement. We distributed residency questionnaires when it was necessary to uncover those cases where people had simply not been here. Now we're distributing residency questionnaires to a much smaller number of citizenship applicants.
Excellent.
And that is giving us faster processing time.
Very good. Can we get a sense of how many incomplete citizenship applications we receive on average?
Currently, it's quite high. But we are bringing it down dramatically. It's around 30% at the moment. But we are trying to work, and we're putting measures in place to make sure that the instructions are very clear and straightforward for our applicants, and this is having some impact as well.
Thank you very much.
Thank you, Mr. Orton. Madame Blanchette will move, please.
Merci, merci à vous d'être.
Thank you for being with us today. First of all, I believe that there were several changes put forward in C-24 that are welcome on behalf of the NDP. I think it's important to underscore this, but since we don't have much time, I will concentrate my attention on those issues that concern us. A lot of people have mentioned the probable unconstitutionality of C-24 with regard to some measures. For example, the intention of residing in Canada, a new measure in C-24 that might contradict Clause 6 of the Charter, the right to mobility of Canadians. Then there is the aspect of citizenship revocation that might fly in the face of Section 15. The Canadian Association for Refugee Lawyers and the Canadian Bar Association have underscored important concerns with regard to the possibility that this is unconstitutional. Following the testimony this committee will hear, I hope we will see a will of the minister to make changes if they are required, because there are serious doubts as to the unconstitutionality of C-24. With regard to the intention or the intent to reside in Canada, I would have a few questions. A person, for example, who receives citizenship and accepts a contract overseas, can that person risk losing his or her citizenship? Well, to begin with regard to our bill and the Constitution, of course we reviewed this bill. In that context, I carried this out, this study, with my colleague, the Minister of Justice, and we believe that this bill is in complete conformity with the requirements of our Constitution. It is reasonable, in our view, to require that a permanent resident wishing to become a citizen express his or her intention of residing in Canada, because it is a requirement of citizenship to reside in this country, in Canada. for 3 out of 4 years at present. Forgive me, I understand your point. You believe it's constitutional, and I find it odd that the minister states that I think it's constitutional, whereas the Canadian Bar Association says it has doubts as to the constitutionality of this. It resembles the approach with C-23. However, my question pertains to the intention of residing in Canada contained in C-24. If a person accepts a contract overseas shortly after having received citizenship, will that person risk losing his or her citizenship? Yes or no? Absolutely not. As soon as a permanent resident becomes a citizen, the person can choose to live where he or she wishes. That's what you would like, I imagine, because in C-24, because of the intention of residing in Canada, if the person leaves Canada for plans that had not been outlined previously, perhaps an ill parent, etc., perhaps the person has to choose a job elsewhere because he or she didn't find one here. In the interim, and one came up elsewhere, there is a risk that because there was an intention of residing here announced at the outset, the person might be accused of fraud. It's a possibility, Minister. The intention of the person to reside in Canada must apply up until the person receives citizenship. Afterwards, the intention of the person can change. Therefore, once citizenship has been received, even if the person leaves the country, there is no risk of revocation of citizenship. As Canadian citizens, we are entitled to freely go and work or reside where we please. And a permanent resident can leave Canada at the time of that choice as well. But if you haven't resided here for 4 years out of 6, you won't receive citizenship. Thank you. With regard to the discretionary power to revoke citizenship or grant it, in what cases can you grant citizenship? Could you give me examples? In cases, exceptional cases, where it's in the interest of Canada that citizenship be granted. For example, in the case of lost Canadians, as they're called. And we already have the obligation to publish in our annual report the number of citizenships that are granted per year, and we plan on maintaining this wonderful tradition. Forgive me, but is it a requirement for you to say for what reasons you are granting citizenship? The reasons are already outlined in the bill. But when you grant citizenship, do you say that you give the number of citizenships granted, but do you also give the reasons? The criteria for special cases are outlined in the bill. If you want the precise language, we could give it to you.
Other finishes. Proceed.
Donc, Monsieur le Ministre, je comprends dans votre réponse.
Minister, I understand that the criteria are outlined in the bill, and you are under no obligation to afterwards explain why you are granting citizenship. And to my mind, this is prejudicial given your intent to strengthen the value of Canadian citizenship. If Canadian citizenship is so valuable, it's a problem for me that a minister be authorized to grant citizenship to individuals without having to necessarily say why, in what conditions, because the minister is minister, obviously, but is also a member of a political party. And this type of discretionary power is worrisome. And the Conservative government is placing more power in the hands of its ministers through legislation. And citizenship can be granted for partisan reasons. There might be a lack of transparency in this process, and this is worrisome. My next question pertains to Canadians who lose their citizenship. Some experts are saying that the bill doesn't go far enough and that there are Canadians who will lose their citizenship and they will not see that if they're depossessed of citizenship, they don't know what the situation will be for them. They may not perhaps recover this citizenship. Lost Canadians, do we have a solution for lost Canadians to ensure that the system will be fair for them?
Your time's expired. Mr. McCallum.
My turn. Thank you, Mr. Chair, and thanks for being here. I have limited time and some concise questions I would appreciate fairly concise answers. First of all, Foreign students are going to be deprived of any credit for their time spent in Canada for purposes of citizenship. And I think we all agree international students are potentially very good citizens. So would you give any consideration to restoring some credit for the time international students spend here before, as counting towards citizenship?
Well, as I think we all saw in today's question period, and we've realized in recent years, it's very important to distinguish between the two different broad categories of status that non-Canadian citizens can have here. One is temporary resident status, and the other is permanent resident status. And what we are saying is that the time that will count towards citizenship is permanent resident status. We don't want those lines to be blurred. It has been very unclear up until now what qualifies. A lot of people who were here as students didn't know that they could apply that time. That seemed to us unfair. The new measures will make it much clearer and also strengthen the residency link that we want new Canadian citizens to have had. We want them to have been here for 4 years as permanent residents, not as temporary residents who can come and go.
Well, thank you. I think the time a student spent here contributes to his or her Canadianness, and I'm disappointed in your answer, but thank you for the clarity. On the issue of intent to reside, it seems to me the answer you gave means there's no purpose in having that provision in the bill at all, because while the person's a permanent resident, they have the 4 out of 6 rule. After they become a citizen, you say the intent may change. So all these constitutional concerns people have are of no value if the intent may change and the law does not pertain. So why have that in the law at all?
Because in the current law, which was brought in by Liberal government in 1977.
I'll take the credit. Thank you.
Which led to unprecedented levels of fraud and abuse with regard to the residency requirement. It became hard to question the determination of people to not be here for 3 years, when in fact they claimed to be here for 3 years, because we had never actually required them to declare their intent to be here. Now we think it is reasonable to ask citizens who are expected to reside in Canada for 4 years to simply declare their intention to reside.
Okay,
that intention had never been made clear before, and unfortunately, some permanent residents took residency, physical presence in Canada, to be optional, and we don't want it to be optional. That was a Liberal policy of neglect that we want to do away with and replace with a clear rule. If you want to be a Canadian citizen, you have to live here for 4 years under this new bill.
I would still say, given your answer, that rule is redundant because the rules are clearly set out for permanent residents, and you say that rule does not apply post-citizenship, so I think it is redundant. The next question I have is that in terms of a person being having dual citizenship, the law puts the onus of proof on the individual. That is very difficult sometimes to prove. It could lead to abuse. Why do you not put the onus of proof on the government to prove the person is a dual citizen rather than the other way around?
The onus of proof for what? That the person is a dual national?
Yes.
The onus of proof begins with the government. It obviously can be disputed by the person affected. And every case that we are talking about here, that I think you're referring to, terrorism, treason, espionage, working with an organization that's fighting the Canadian forces, will involve some judicial standard of review or judicial process. So it's not just the government acting alone. It's certainly not just the claim of the individual. There is going to be due process to different degrees with regard to these different crimes.
15 seconds.
Okay, since I don't have time to refute that chart you held up, the downtime for processing time is a prediction. The uptime historically, which doubled over your period in office, is a fact. So my question is, why did you allow it to double? You acknowledged in your document it was due to lack of resources. Why the lack of resources? And is any of the money from the 2013 budget going to actually be spent in the current fiscal year, because it was not in the estimates?
We're proud of the fact that citizenship is more popular than ever. We're proud of the fact that last year was the largest number of applications received in history. We're proud of the fact that the naturalization rate continues to grow. And we're proud of the fact that we had 75,000 new citizens accepted in the first 3 months of this year, thanks to the resources we gave to this process last year. So we won't apologize for the fact that more people want to come to Canada than ever before, because there are more jobs in Canada than in many other places.
Thank you. Mr. Leon.
Thank you, Chair, and thank you for the Minister and staff for appearing. I just wish to share a little bit of my experience of attaining citizenship in Canada. I came here as an international student in 1968, and you're quite correct. At a time, I wasn't quite sure whether I was going to stay in Canada or obtain my education, do my graduate studies in the United States. So the point that the new Act is looking at, where you have to declare your intention to stay, I think it's quite correct in that, you know, there's very often many foreign students who come here do not know whether they're going to do undergrad here and graduate studies in the United States. And anyway, I did acquire my citizenship before the change in 1977, so there was a total of five-year residency requirement. And I think just having been here since as a Canadian since the 76 era to the present, I have seen many cases of people who do come here who don't show that intention to stay, who don't show that they're here to help us build this country that has move on. What I wish to address more specifically is the language requirement. I understand that when we did previous studies that people who have command of one of the official languages do very well in terms of job acquisition or in being a fully participating member of the society. And yet often I hear from the opposition that, you know, we're making the language tests harder, we're barring more people from attaining citizenship, and we're also making it harder for youth and seniors to be citizens. And so what I like you to say, Minister, is that perhaps you could share with us some of the facts, some of the reasons, some of the logic behind why it is necessary for citizenship to attain citizenship, to have that language skill in order to survive in this country. Yourself, as I understand, have been a diplomat in various countries, and you know that language itself is a very important tool to either for business, for government, or to be able to live comfortably in our society.
Right. Thank you, Mr. Long. Yes, I mean, many of us who are born here are still working on our English and French, and that is a process of lifelong that never ends. But let's be clear, language requirements have been part of citizenship and were first introduced in the Citizenship Act in 1947. This is nothing new. All the studies that we have from within government, from outside government, from other countries show that knowledge tests, that tests one's knowledge of the country of which you're becoming a citizen and official languages knowledge help with successful integration. There are better outcomes from those that have this kind of knowledge. And so we're quite confident that the measures we're taking are moving us in the right direction. Moreover, new Canadians, permanent residents who are becoming citizens are responding to this challenge. Over the whole period from November 2010 to September 2013, the pass rate for the citizenship test, that's over 3 years, almost 3 years, was 80.8%. But in January 2014, this year, it was 87%. In February of 2014, it was 92%. So as these measures have been introduced, as people have become used to the predictable assumption that they will have to take these tests, they are making the necessary preparations and they are having success. That serves Canada well, and it serves new Canadians very well.
Now, in the new form English testing, do we then go out to an independent third body to get some sort of uniform testing result, or is this handled internally by the department?
Thank you for your question. So there's information on the department's website, and you're quite correct. A citizenship applicant can go to one of the third-party test bodies that meet our criteria for tests to be equivalated with the Canadian Language Benchmark Level 4, which is a basic official language capacity. And there are a range of other forms of evidence that the department accepts, academic evidence, evidence that the person has been through language instruction for newcomers, settlement training that the government funds, which is free and has achieved a certificate out of that the CLB4 level has been obtained. So applicants do have a number of types of evidence that they can either pay for or get for free at their disposal.
And can you share with us whether the level 4, is it out of a scale of 10 or a scale of 12? Because regardless of what age a person is, I think, you know, a society like ours, which requires a reasonable level of language competence in filling out income tax form, giving directions in case of emergency, or even going to hospitals, I think we need to have that language skill. Could you share with us where 4 is in terms of the total scale?
It is on a total scale of 12, so it is a low to middle level of mastery of our official languages. One would be expected to be able to formulate simple sentences, fill in a form, perform the basic tasks of life. But obviously, most Canadians new Canadians go very quickly well beyond that level. We're also very conscious of the fact that with regard to certification by third parties, this can be open to abuse as well. A British colleague was telling me just yesterday about a very large case in their country of a third-party language validating authority that somehow was giving out this certification to people who hadn't really achieved the level. So this, even this criterion for citizenship requires constant review, supervision, to make sure that it's being applied uniformly and met by all of the new Canadians who want to become citizens. The vast majority, obviously, achieve it honestly, and we want that to become the firm and expected practice.
Thank you, Mr. Minister. Ms. May, very briefly.
Thank you, Mr. Chair. I appreciate the chance to ask a very brief question. I want to thank the Minister for doing some work on the Lost Canadians issues. It's taken a while to get that sorted out. But I'm baffled by the attention being given to the idea of fast-tracking citizenship for people serving the Canadian Armed Forces. I have the website of the Canadian Armed Forces open here, and it says to apply to the forces, you must be a Canadian citizen. I understand there's a rare exemption. The Chief of Defence Staff can appoint someone not a Canadian citizen if it's necessary, if, quote, a special need exists. How many people would possibly be in the Canadian Armed Forces who aren't Canadian citizens, and why are we essentially making such a thing of this particular fast-tracking? Thank you, Mr. Speaker, and thank you, Mr. Chair.
We have currently 15 permanent residents serving the Canadian Armed Forces, 140 of other nationalities serving on exchange with Canada. And of those exchange officers or soldiers, about 30 would have at least 3 years service with the Canadian Armed Forces, so those would be the people who qualify. It's a very small group. Traditionally, as you say, we've had recourse to it when permanent resident has a competency, a form of expertise that other Canadians don't have in the Canadian Armed Forces. And it recognizes the fact that all of those who have the right to work here should, in principle, have the right to work in the private sector or the public sector. So it's not a widespread practice in the Canadian Forces, but it's certainly not prohibited by law.
Thank you. Mr. Sandhu.
Thank you, Mr. Chair, and thank you to the Minister for being here. Mr. Minister, you talked about these reforms are taking place after decades of neglect by previous governments. I just want to make it clear for this committee, it's your government that's been in place for the last 8 years. So obviously, these neglects and abuses have been, if they're taking under place your government. There seems to be quite a bit of trend of abuse of government programs, whether it's temporary foreign workers, whether it's the Senate expense scandal, whether it's inability of this government to go after the tax cheats. So there seems to be a lot of abuses that are going on under your government. It seems to be a trend there. But my question to you is, If you're so much concerned about some of the abuses that are going on, you brought this bill to the House in February. Why not bring it up for a second reading?
We have had debate on second reading. We would be delighted at the end of the next time in the House devoted to second reading to vote all together to bring it to committee for study. That would be a great breakthrough on behalf of the many Canadians waiting for speedier processing of their citizenship applications. And we will take your suggestion on board. We and look forward to NDP support at second reading for early move to committee. The point we made about decades of neglect doesn't refer to our government. We're grateful if you predict that we will be here for a decade or more. We certainly look forward to renewing our mandate with Canadians and earning the confidence of Canadians at the next election, but we've only been in office for 8 years. The neglect and the failure to address fraud with regard to the residency requirement, the issue of lost Canadians, the issue of revoking citizenship for those who engage in extreme acts of betrayal of their Canadian citizenship really belongs to the Liberal Party, which brought us the bill of the last version of this bill, which is 1977.
Thank you, Minister. Under this bill, Bill C-24, I've just got a question here. The Bill C-24 proposes to change the Citizenship Act to expand the age of requirement for applicants from 14 to 16 to successfully complete both language and knowledge requirements. These requirements compromises the Convention of Rights of Children under the age of 18 by violating the rights, child's right to family reunification under the UN Convention on the Rights of the Child. What is the rationale behind this change, Mr. Minister?
Well, we have the utmost respect for the Convention on the Rights of the Child and the optional protocols to which we are a party. We will uphold our international obligations in every way. At the same time, we, like you, recognize that 14-year-olds are generally in high school. They generally take many more tests and harder tests, in fact, than the citizenship one that is being proposed for them starting at the age of 14 right now. We think that's fair. The test results for younger people show that they're almost certain to do as well or better than adults. And it seems reasonable to us that high school age children and working age pre-retirement adults should be subject to the language and knowledge tests. To give you an example, more than 57,000 students participated in the Historica Canada Citizenship Challenge in 2014 and wrote a citizenship test based on Discover Canada. 70% of those in grade 9 passed the test, which means they achieved a score of 75% or better, which is the same pass grade as for the official citizenship exam, and they weren't getting citizenship. So with that added inducement, we would count on people of that age doing even better.
Thank you. And you mentioned another area of concern to me is in regards to the foreign convictions can be denied citizenship if those charges were laid outside of Canada. And you talked about this in the House in regards to having some sort of judicial review. Can you please describe the criteria and the process by such a review of foreign convictions will be done by CIC?
This is the type of review that we're very accustomed to doing with our delegated decision-making model. Highly trained, independent public servants make these determinations on the basis of solid information provided to them with regard to visitors to Canada. Those convicted of criminal acts outside of Canada in democracies with the rule of law are inadmissible to Canada. The same should be true for citizenship.
Thank you. Mr. Shuri.
Well, thank you, Chair, and Minister, thank you to you and your department for appearing us here today. I wouldn't be surprised by the line of questioning from NDP, because this is the group, this is the party who supports the left-wing groups like no one is illegal. But let me talk about something else today. I want to talk a little bit about the provisions in C-24 that strengthen and
clock for a
protect
minute.
Canadian values.
Mr. Shorey, I have to keep order in here, and I don't want you. And everybody, there's a lot of antagonism going on in here, picking on Liberals, picking on NDP, and they're going to pick on you next. So I just ask that everybody refrain from picking on each other.
Thank you, Mr. Chair. And let me get back that I want to talk about the provisions in C-24 that strengthen and protect Canada's values. And I, of course, had a private member's bill, as everyone knows, that dealt with protecting Canadian interests and promoting integration. These two provisions were fast-tracking citizenships to those who serve in the Canadian Armed Forces and stripping citizenship from those convicted of terrorism and treason. I know, Minister, that these provisions enjoy broad support across a broad spectrum of Canadians, and I'm very thankful to you to adopt the contents of my bill in C-24. Can you please share with the committee the reasons behind protecting and promoting the values of Canadian citizenship through these two provisions? And my secondary question is, I know that you have been crisscrossing Canada on Bill C-24 to discuss it with the stakeholders and constituents. Can you also tell us what are you hearing from local constituents, stakeholders, and Canadian public on C-24?
Thank you so much, Mr. Choi. First, on the second part of your question, we're hearing uniformly across the board from Canadians, those born here and those who immigrated and in many cases are new citizens, that the residency requirement and all the other measures to back up the integrity of Canadian citizenship, to make sure that the rules are followed for obtaining Canadian citizenship, are the right moves for today. And almost everyone we speak to emphasizes that we shouldn't just have these rules, they should be enforced uniformly. And any failure to enforce them undermines the value of Canadian citizenship. Secondly, on your mention of permanent residents serving the Canadian Forces, lost Canadians, we rightly celebrate those who choose to serve our country so soon after choosing to live here. That's what this is about, honoring those who serve the Crown abroad, not penalizing them for being in the Philippines or South Africa as defense attaches or RCMP liaison officers or foreign service officers when they have children there, and also resolving the issue of lost Canadians, which should have been dealt with much earlier. The special grants of citizenship, just to conclude an earlier part of our conversation, have to meet two very firm criteria. One is for unusual hardship. That has been the case of the lost Canadians. That's what we've used to resolve their cases. And if there are new cases that anyone around this table wants to bring to our attention, please do. That's what this special award of citizenship is for. Or service to Canada. And believe me, the standard for determining what service to Canada is must be a very high one. We need to be able to defend it as a government, defend it in public. The people who receive the citizenship are proud of it. They will talk about it. They have the right to privacy, obviously, but these criteria are high standards, and this tool of special awards of citizenship is not unusual. It exists in every similar jurisdiction around the world, governed by slightly different criteria in each case, but it's essential to meet the kinds of challenges that we have found through the history of the development of our citizenship.
You may want to make a comment of what are you hearing from local constituents, stakeholders, and the Canadian public on C-24 during your Canadian tour?
Well, they like the residency requirement. They also like the measures that you proposed initially and which have been taken up in this bill. There are those we want to honor and historical injustices we want to correct by awarding citizenship to lost Canadians, to those who serve in the Canadian Forces. But there are also those who betray the trust that citizenship represents. Most of us receive our citizenship at the moment of our birth by being born in Canada. Many others receive it by earning it through residency, by following the law. Now there will be a few, only dual nationals, who, if they go to the absurd length of spying against this country, committing treason against this country, fighting the Canadian forces with an enemy formation, will face the revocation of their citizenship for those reasons. And these are measures that other democracies have, often an even more robust measure. It is right that we should be able to expect that basic level of loyalty to Canada from dual nationals.
Thank you. Mr. Daniel.
And thank you, Minister, for being here, as always. It's a pleasure to have you here. My question is about some of the revocation issues, and in particular, we've noted that the Liberals and the NDPs, not surprisingly, like to defend serious criminality and pretend that those convicted of 6 months in jail or more are not serious criminals. The leader of the Liberal Party, Mr. Trudeau, has said he would repeal...
Stop the clock, please. I guess you didn't hear me before.
Chair, what do you expect me to call them?
Well, you know, we're here to study the bill, not take shots at each other. And I just,
we're
all
just
I
making
need
a
is
statement.
you start aggravating these people, they're going to start going at you. So I'd rather you don't attack, make political shots at the opposition. Ask your question.
Thank you. I will do that, Chair. Can you tell me what impact is on the victims and the law-abiding Canadians if we do not remove citizenship from those serious foreign criminals before they commit more crimes and victimize more innocent Canadians?
The simple answer is that there's an inconsistency in our laws at the moment. Under the Immigration and Refugee Protection Act, someone convicted of a crime or someone who committed an act that would have been a crime in Canada is admissible to Canada as a visitor. At the moment, our Citizenship Act does not make that person ineligible for citizenship for having committed the same crime. That's an inconsistency. We're cleaning that up. It stands to reason that those who've met all of the requirements of citizenship, they have the skills, the language, the competencies, the education to come here, should meet the basic criterion of not having a criminal record as determined by a jurisdiction that we respect in a fellow democracy with the rule of law. That I think, is common sense to Canadians. And in the case that you mentioned of war crimes, we have a particular responsibility, both for visitors and for those applying for citizenship, to screen people for just that. As we start to have permanent residents and citizens coming from all parts of the world, often regions or countries that have had terrible conflicts where atrocities or war crimes were committed, we have a responsibility to the Canadian people under our laws to make sure that the perpetrators of those crimes do not become our immigrants or our citizens.
Thank you. How fair is it to revoke citizenship for a foreign offence? What will the assessment of equivalence between the foreign and domestic offence include? And will this include equivalence of a judicial process?
Well, as I mentioned earlier, a conviction in a country that is totalitarian or doesn't have the rule of law, is not a democracy, a conviction that was political in nature, would not be grounds for refusing citizenship in Canada. We would have the ability to make that determination. On the other hand, a conviction for terrorism, someone sentenced to at least 5 years of imprisonment for terrorism, will not only prohibit someone from becoming a Canadian citizen, but in the case of a dual national, could lead to revocation. For these serious crimes, we think that there is a need to send a very clear message that citizenship is a responsibility that we all have. And in the case of dual nationals, you can lose the privilege of being a citizen if you engage in these signal acts of disloyalty. But for all of these offenses, there is some level of judicial review or proof that is required either in the federal court or in a foreign jurisdiction that where an equivalence with our system is recognized.
Okay. Just on that same line, how fair is it to revoke citizenship without a hearing? What criteria will the minister use for determining whether to hold a hearing?
Well, the decision is certainly not taken lightly, but in a case of criminality, if a person made a written declaration that they had no criminality to declare, when in fact they were charged or convicted prior to taking the oath of citizenship, and that comes to our attention, that should be grounds for revocation. In the case of identity fraud, if a person impersonates a deceased family member, and that is found out beyond shadow of a doubt as part of the review of the application, that's grounds for revocation. And in the case of residency fraud, if someone declares that they've met the residency requirements for citizenship, when in fact conclusive evidence shows that they have not lived in Canada during the relevant period, that should lead to revocation. And if I'm not mistaken, all of these decisions can be appealed to courts of law, but these are objective criteria that must be met. When they're not met, revocation follows.
Thank you, Mr. Daniel. Ms. Blanchette-Lamothe.
Merci. Alors,
Thank you. I would like to come back to the intent to reside in Canada and what you stated. If I understand correctly, an individual who declares his or her intent to reside in Canada and obtains his or her citizenship and leaves Canada to live in a foreign country, that individual won't be accused of having made a false declaration in view of obtaining citizenship, and won't see citizenship revoked for having left Canada immediately after having obtained citizenship. Is that the case? Absolutely. The declaration of intent to reside in Canada relates to the 4-year period in the context of the new bill, the 4-year period out of 6 for which the person must reside in Canada to qualify, and not the period of time after having received citizenship. No. And clearly, we will continue to promote residency in Canada. That's the whole point of our immigration system and our citizenship program. But we recognize the globalized nature of our economy, and a new citizen might be offered a job by a Canadian company in Berlin, Hong Kong, or Kinshasa. Thank you. That's not what I had understood, and it's apparently with several lawyers, perhaps even the Canadian Bar Association, and they don't have the same interpretation of the bill as it is drafted. But we'll hear from lawyers, and we'll see if there are ways of improving the Act in order that your intent be well understood. However, with regard to the elimination of the use of the duration of residency in Canada because of Bill C-24, once it's in force, students, for example, won't be able to see their residency time counted in Canada, even if they worked, even if they were paying taxes and did so for several years. They will no longer see this taken into account. There are years of residency in Canada before they obtain permanent residency. Will that apply to students? To all students? Or rather, will it apply just to those who will arrive after this bill is adopted? Or will students see their application postponed as of now? And why this decision? The new measures will come into force once the bill has been carried. And I must underscore the fact that the possibilities of immigrating to Canada, these possibilities offered to students, are greater now than in the past, thanks to the Experience Canada category and thanks to the provincial nominations programs, which target students and temporary qualified foreign workers. Thank you.
You've been here an hour, and a lot of issues have been raised, and we thank you for coming, sir. You are excused.
Thank you very much.
We will suspend.
Chair.
Staff from the ministry with us. I've given their names earlier. We're going to take the position that we're starting round one again. So, Mr. Opitz, you have the floor for 7 minutes.
Oops. Thank you, Mr. Chair. Thank you all for being here. It was good to see the minister here as well. You know, and this is something that for me has a lot of meaning, especially on the Canadian Forces side, having served before, because anybody that produces or commits an act of war against and who is a Canadian citizen against Canadian Forces personnel, like those gentlemen uniformed back there, I don't think is something that should be tolerated, definitely in this country. And you know, the standards of citizenship, I think, should be high. I think the bar should demonstrate the integrity of what citizenship is. Our friends of the Liberal Party had most of the last century to be able to put that in place, and they hadn't done that. And our friends from the NDP, you know, although very, very nice people, are somewhat unrealistic about what some things in citizenship are, because certainly when my parents got here after the Second World War, they took it all very, very seriously. But I'm not sure who would answer this right away, but what are some of the factors that lead to longer processing time? Is that you, Mr. Orr, and Mr. George? It's a fair question, Mr. Chair. And
you know what? Stop the clock. You're the third person, the third government member I've commented on. You really, this isn't a place to take shots at
Mr. Chair, it's not your place to edit my comments.
It is my place to make sure there's order, and I don't think it's appropriate to attack other members of this committee.
I was asking my question, Mr. Chair. Mr.
All right, well, you go ahead, but you heard what my objection is.
Well, I heard it, but it's not your place to edit my comments. They were fair.
It is my position, but you
disagree.
have the floor.
So what are some of the factors that lead to longer processing times?
There have been a number of factors which have influenced processing times over the last few years. First of one I would mention is the increased levels of immigration over a sustained period, and inevitably that leads to greater numbers of citizenship applications a few years down the road. So there's been a direct correlation between those two things. I think in the last few years as well, we have put greater emphasis on integrity in the program, and that has also meant that sometimes processing has been slowed down as we pay greater attention to the integrity issues. There's also been issues of sometimes of citizenship judges' positions being vacant, which has slowed down some processing as well. But I think there have been a very large number of measures which we've taken to try to increase the speed of processing in recent years. There was a considerable amount of money, $44 million, which was given to the department to look at processing from the Economic Action Plan of 2013. Some other things we have done is that applicants up front must supply evidence of their language ability, which in other words, one step of the process is already done before we get the applications now. Secondly, since June 2013, we have allowed those who do not pass the knowledge test first go around to take it again a second time. And that's been very successful, with over 50% of those people who've taken it a second time succeeding on the second occasion. The third way that we have tried to increase processing is that sometimes family members were held back because we used to process a family all at once. Now they have the choice. If a family wishes, certain members of the family wish to go ahead because one is for one reason or another, nothing to do with program integrity, but for one reason or another that the one individual is not ready for citizenship, the rest of the family can proceed. So there are a number of measures that we've taken to try to improve processing times.
All right, sir. And you mentioned integrity a couple of times. So how are the changes in this bill, in Bill C-24, affect the integrity of the citizenship program and the fraud that has been seen in the citizenship application process?
Thank you for your question. So there are a number of proposals in this bill that will help significantly reinforce our efforts underway to improve the integrity of the citizenship program. You heard the minister speak earlier about changes in the requirements, for example, residence, which is one of the main areas where we have fraud. Now we're moving to a more objective test, so backed by objective evidence. When the government has the availability of the entry-exit tool starting next year, and that will then help the decision-making process be much more clear-cut and identify those cases right up front in the process where someone is saying that they meet the residence requirement, whereas we may have objective evidence that that may not be the case. Those cases will be identified much earlier on now, which will be to the good. And then the bill itself proposes a range of other measures to reinforce integrity. One of the ones the minister mentioned had to do with a new authority to designate a body to regulate citizenship consultants, similar to what exists under the Immigration and Refugee Protection Act, to hold these consultants to similar ethical and professional standards of conduct, and at the same time bringing the offences and penalties for citizenship fraud up to date to provide some additional deterrence, as well as some of those measures around the revocation process that the minister spoke of earlier.
Just staying along that line, so at the present time, approximately what percentage of the CIC caseload is related to residence fraud? Do you have a number, approximation?
I believe it's about 85% of the revocation cases at the moment are related to residency fraud.
Wow.
And that gives you some indication in that particular area, but it is one of the key areas where we would go to hearings as well with judges over residency questions.
Okay. I'm just getting to the Canadian Forces for a sec. So if somebody, if a person's committed an act of war somewhere in the world against Canadian Forces or even here, and their citizenship gets revoked, is there an ability for them to reapply for citizenship at any time?
So, is this on?
Yeah.
So in answer to your question, so persons who they are subject to decision by the federal court that they are an individual whose citizenship is being revoked on the grounds that they are a member of another country or a foreign armed force that's engaged with the Canadian Forces in armed combat, and so the federal court is making a decision to revoke them on that basis, would be barred permanently from subsequently applying or for Canadian citizenship on the basis of the seriousness of the circumstances that gave rise to the revocation in the first instance.
Thank you. Lamothe, please.
Merci.
Thank you. I'd like to ask a few questions on citizenship judges. They're currently citizenship judges who hold hearings and who make decisions, and these judges are independent of the department. Is that correct? And according to Bill C-24, who, in the place of judges, will make decisions that judges currently make? Well, according to the bill, what is proposed is that we will move from a three-step decision-making process to a one-step decision-making process where it would be the minister or citizenship agents designated by the minister who would decide in the vast majority of these cases, particularly in cases where an agent would not be able to approve the request for citizenship because there are concerns that the person making the request does not meet residence criteria. So those cases would be referred to citizenship judges as they are today, where a transitional 5-year period decision would be taken. That transitional period could be renewed at the end of 5 years by the minister if necessary. So judges will be responsible specifically for those cases. All other cases will be decided by the minister or by citizenship agents designated by the minister. And citizenship judges will, of course, continue to play a very important role in undertaking all citizenship ceremonies, which is the final step before becoming a Canadian citizen. And currently, as it will be the minister or those delegated by the ministers can appeal citizenship judges at this time. Is that correct? Yes. And in the case where it would not be the minister, well, in a case where it would be the minister or a person delegated by the minister would be making a decision, who could make appeals at that time? Are we eliminating the possibility of appealing a decision? How will that work? Well, the possibility of appealing or of reviewing a decision, a negative decision, has not been eliminated. We have to keep the context in mind here. The vast majority of in the case where it would be a minister or a person delegated by the minister would make the decision, if there's a negative decision, the person making the request could ask the federal court to review that decision with the authorization of the federal court. So who could ask for an appeal? The person requesting citizenship. So that person could ask for an appeal, whereas at this time it's the department or the minister or the person delegated by the minister who could make an appeal. So if it's the minister making the decision, that the person making the request could make the appeal. So nobody else, though, could make an appeal. The minister couldn't appeal his or her own decision. Yes. Okay. Thank you. Now, concerning the power of revoking citizenship, the recommendation to allow the minister to give or take away citizenship, was that recommended by the department? Well, the minister and the government make decisions after taking into account counsel provided by the department. However, in this particular case, I couldn't offer further comments. And based on what I understood from earlier, a minister could give citizenship without having to justify the reasons why it has been given. Well, according to the bill, the minister can only grant citizenship in exceptional cases according to criteria that are set out by the Act. And so the minister mentioned it earlier. There are two criteria for the exceptional granting of citizenship. Those are those who have rendered an exceptional service to the country, or those who have suffered an exceptional hardship. And who decides if exceptional service has been rendered to the country? Is that at the discretion of the minister? Yes. But it would be up to the person to prove the circumstances that apply in that case. But there is still then some subjectivity here. There's no criteria that are saying specifically what those services would be, or there's not a necessity to make that public. Yes, it's discretionary. Thank you. In terms of language tests for children aged 14 to 18, if a young person fails the test but the parents pass the test, what would happen? Would that complicate things if the family were to travel, for example? Or would the child at 14 years automatically receive citizenship even if they failed the test? Could you tell us more about the procedures there or the protections that are in place in this bill to make sure that children are not excluded from their families and so that they can have the same travel documents, for example, as other members of their family? Well, that's a very interesting question, and it's something that we are looking at as we prepare for the potential adoption of this bill. However, as the minister said earlier, according to the trends with the Historic and Dominion Project, the institute which had 57,000 students from 7th grade to 12th grade do that test. The majority of those children have passed the test. That suggests that high school students will likely have decent levels of success in that area. However, in terms of our preparation, we're going to look very specifically at tests that are made available to young people. We'll compare them with the knowledge test that is available for adults. So the test will be adapted to young people? Quite possibly. That's one of the considerations that we're looking at as we look at implementing this bill. You said that most students should pass, and I understand that this won't be a problem for the majority who will pass, but in terms of the minority who don't pass the test, that's where the problem might be. So I'll ask the question again. If a child of 14 years, a 14-year-old child fails the test and his parents pass it, could that cause problems if the family wished to travel abroad or in other contexts? Well, I would add to my answer that, as the minister said earlier, we currently have a system in place where those who fail the first time can pass the test a second time. So they can try a second time and at least half pass the second time. And so I think that the situation that you're describing here would be very exceptional.
Thank you, Mr. Chair, and on your instructions, I'll be very polite to Conservatives. I won't mention them. I'm a bit confused, however, over this intent to reside provision, because, as you know, there had been quite a lot of concerns expressed by lawyers about the constitutionality of it and the idea that a person could have his citizenship revoked if, having expressed an intent to reside in Canada, he then lived elsewhere. But now the minister's just told us that it doesn't apply at all after you become a citizen, that your intent may change. And before you're a citizen, when you're a permanent resident, it doesn't really matter what your intent is. You're legally required to be here 4 out of 6 years. So I guess my question is, what purpose does it serve to have it at all, since it doesn't apply after you're a citizen and is not needed before? Other than perhaps to frighten people into the mistaken belief they could have their citizenship revoked. What's the point of it?
Well, Mr. Chair, our intent certainly wasn't to frighten people. We looked at this as something that would reinforce the expectation that citizenship is for those who intend to make Canada their permanent home. And it was seen as another tool to reinforce that message. Another tool, another way to reinforce that message that citizenship is for those who intend to make Canada their permanent home.
But does it have any effect? Because it doesn't apply post-citizenship.
That's correct.
Rules are in place pre-citizenship. So would anything be different if that provision were not there?
Well, if you declared that you had no intent to live in Canada post-citizenship or after your ceremony, then we could, refuse the citizenship in that case. It's an attestation on the part of the individual.
You mean you could revoke it post-citizenship?
I think that would be exceptionally rare, but if someone were to come forward, and this is a hypothetical situation, so I'm treading on thin ice here, but if it were absolutely crystal clear that someone had no intent to reside in Canada before they were made a citizenship, and it was made clear to the government and clear to the ministry, then it could be something that we would pursue. But I would say that would be a very exceptional case.
But the minister said you could always change your intent after becoming a citizen.
That's correct.
So if that's the case, your pre-citizenship intent wouldn't matter, would it?
If you had, this is an attestation on your part that you intend to stay in Canada. What happens after you become a citizen, and those opportunities are a completely different thing, and that provision is not meant to apply to that. If you had no intent to reside in Canada post-citizenship, that you did not intend to make Canada your home, and you were untruthful in terms of your attestation, then that's something different.
All right, I guess I'm as confused as I was at the beginning. So you're saying effectively, in theory at least, a person's citizenship could be revoked post-citizenship if that person did not have the intent pre-citizenship of residing here.
If that were very clear, and it were clear that the person had misrepresented themselves, then yes.
Okay, I think there's a difference between what you said and what the minister said, but I'll leave it at that. On this question of expenditures of money to reduce citizen waiting time, at their last meeting in the budget 2013, the government committed certain funds, but according to the estimates, there weren't any funds for the year 2013-14. So does that mean that you're in this sort of gearing up phase and the money will all spent in the subsequent year, or how do you explain the commitment in the 2013 budget and the lack of money in the estimates for the current year 2013-14?
For the year 2013-14, Mr. Chair, the department was able to cover a lot of the ramping up in the citizenship program through lapses in other areas of the department. So this year, in 2014-15, I believe it is $28 million will be spent to improve processing time in the citizenship program. As you recall, there were $44 million assigned to the department through the Economic Action Plan for Citizenship.
So you're saying you did have expenditures in 2013-14
we did have expenditures
through lapsed funds?
That's right, which we covered through lapses.
Mr. Daniel.
Chair, and thank you folks again. I'm just wanting to explore the role of the citizenship judge in the process and how we actually, how they're actually used to improve the process. So, can you confirm the role of the citizenship judges will have in the faster processing model in Bill C-24?
Thank you for your question. Under the new processing model, we're going from a three-step to a one-step decision-making process, where in the vast majority of cases, the minister or a delegated citizenship officer would be deciding on the vast majority of citizenship grant applications. However, there would be a minority of cases where citizenship judges would continue to decide, and those cases would be the ones where the delegated citizenship officer is not satisfied that the applicant is meeting the residence requirement. So those cases would continue to be referred to citizenship judges for a transitional period of 5 years, which at the end of 5 years could be renewed by the minister if deemed necessary. The citizenship judges would also continue to maintain the very important role of conducting citizenship ceremonies, which of course they do now, and which is the final step that applicants complete before becoming Canadian citizens.
Maybe you could just expand a little bit on what the role of citizenship judges would play, apart from dealing with the residency cases.
So other than deciding on those residence cases that are referred to them and conducting citizenship ceremonies, of which there are many hundreds across the country over the course of a year, citizenship judges would also fulfill the important role of doing citizenship promotion, which is part of their duties now. That would continue.
Okay. What percentage of applicants use non-PR time towards their citizenship, approximately?
So in actual fact, not very many applicants take advantage of the ability to use non-permanent resident time now. It's less than 15% of applicants overall.
Okay, thank you. Now, just one of these residency questions that affect obviously a few people, but not a huge number of people. What about the residency requirement for people whose jobs require extensive travel? for instance, those in the airline industry or those whose work requires constant travel, will there be any exceptions to the rule that the 4 years of physical presence will be required to meet the requirements for citizenship?
So there wouldn't be an exception to the requirement for 4 years of physical presence under the bill. That is a requirement under the bill. However, it would be 4 years of physical presence out of a 6-year window. And so those who have to travel quite a bit for their work or for family reasons would have the flexibility to use the full 2 years out of the 6-year window, however they choose over that 6-year period for times that they may need to be away, and that would accommodate people in all kinds of lines of work.
I still don't see how somebody who is maybe an airline air hostess who's traveling, 3 or 4 days a week and wants to keep their job can actually meet the residency criteria. Is there anything you can add to that, or anybody?
It'll depend on the individual circumstances, but as I mentioned, people can be away for a full 2 years, and that period of time can be staggered at any time over the 6-year window. So the time that the individual is in Canada counts towards the physical presence requirement, and the time that the person is away, doesn't count.
Okay, I think those are all the questions I have, Mr. Chair.
Mr. Tsabiasin.
Thank you, Mr. Chair, and thank you to our officials. I have a few questions. I'm going to try and jump around a little bit, change topics. So first question is about, in the Minister's comments, he spoke of the reforms to the Citizenship Act hadn't been, what did he say, decades of neglect by previous governments, and then there was a question about, was it the current government, and he said that the current Conservatives have only been in government for the last 8 years. So I'm wondering if you can give us statistics on the wait times for citizenship applications and the wait over the last 8 years, and also the wait times on the residency questionnaire, because I have many people contacting me directly about their residency questionnaire wait times and their wait times in general for citizenship, because they've been permanent residents for many years and want to be Canadians and are stuck in the queue waiting.
Perhaps I can first of all talk about the residency questionnaire, which there was a great increase in the number of residency questionnaires which were sent out about 18 months ago or so. We have tried to reduce that significantly. We've gone through a real blitz to try to reduce the number of residency questionnaires and moved about 71% of those who had residency questionnaires into straight processing and onto testing. So that's been very significant indeed.
Do we have actual statistics on how? Do you have the actual statistics on how many and how long they've been waiting over the last 8 years?
Actually been waiting? No, I don't. They're about.
Maybe you can.
Yes, we can follow up with specifics on that because it becomes a somewhat complicated story.
Yeah,
but
for
yes,
sure. Maybe you can provide that to the clerk for us. Thank you, Mr. Orr. I'm going to switch gears a little bit to the official language knowledge requirement. I'm just wondering, I think it was Madame Girard, when you were answering, you were talking about that this is actually a good thing and that it shouldn't be too difficult. I'm wondering if there's an exception for children with learning disabilities for the language requirements and the test.
So thank you for your question. Whether it's an adult now or a younger person as proposed under the bill, there is the ability now and under the bill to apply for a waiver if someone is unable for some reason to meet a requirement like this, whether it's because of a disability or a health condition. And so that's something that exists now that people can, where people can request that consideration, and it would be under the bill as well.
Okay, so my question is with respect to for children, especially for undiagnosed disabilities, because I've been trying to find the statistics on the number of undiagnosed disabilities, especially learning disabilities and other non-visible disabilities in children. And I was looking at actually HRSDC's website that had a Statistics Canada's details from the Participation Activity Limitation Survey from 2006. It states that children ages 5 to 14 years as of 2006, of the children who have disabilities, 72.7% are boys with learning disabilities, and 63.3% of girls have learning disabilities and chronic, and these are just diagnosed children. And we know that it's on the rise, where we're realizing that there are a lot of children who haven't been diagnosed and are going through the system and having difficulties because their learning or chronic illness or whatever it might be, some sort of disability hasn't been diagnosed. What happens for those children who are now 14 and can't pass the test because they have a disability that's not diagnosed? Do they just don't get to be Canadians with their parents and their family members?
So whether it would be an adult or a young person under the bill with an undiagnosed learning disability, as you rightly point out, not everyone may self-identify up front. And so we will be looking closely at our implementation preparations to ensure that people in those circumstances will continue to be able to get access to a waiver, whether they self-identify from the get-go or whether it's, perhaps they've sat one test and they haven't been successful. And we may then need to identify them as somebody who's potentially need a waiver.
And how is that going to be done? Because the minister also said earlier today that people won't be given an unlimited number of attempts at these tests. So how is that identification going to happen?
Point of order, Ms. Fitzmason. Mr. Shorey.
Thank you, Mr. Chair. I just want the member opposite to give clarification. How many, the number she mentioned from HRSDC, if she has a clarification, how many of these number are immigrants to become citizen?
I think she has the floor. I don't know whether that's a point of order. That
not.
might be an opportunity for you to ask that question.
Thank you, Mr. Chair. I think you had a chance to finish your question. With respect to the intent to...
You've got about 2 seconds, so make
reside. Okay, the Library of Parliament analysts have identified that this change is actually going to the pre-1977 era of citizenship legislation in this country. Why is this change happening?
So for the intent to reside, it's, as others on this panel have commented, it's the purpose of communicating that, citizenship is for those who intend to make Canada their home.
Mr. Shorey.
Thank you, Mr. Chair, and witnesses, thank you. Let me start with my point of order. I would like the officials to confirm or not confirm that the numbers my colleague mentioned from HRSDC website, do you think or do you know that these numbers are 100% immigrants who are to become citizen?
Mr. Chair, I'm sorry, we're not familiar with the numbers that the member had mentioned, and so we would have no way of knowing at this point how many of those children were immigrants.
Can you please look into this and get back to the committee to confirm or advise the committee whether these numbers are 100% immigrants?
Mr. Chair, we'd be happy to get back to the committee.
Thank you.
If you don't have it, maybe you can tell us you don't have it, but that's an undertaking. We would appreciate getting that. Thank you.
Thank you. Now, let me ask something about consultants. Why do citizenship consultants to be regulated? Why do you think that they should be regulated?
Well, unfortunately, as the media has reported, there are several thousand individuals across the country who are under our CMP investigation for citizenship fraud, in the range of 3,000 citizens and 5,000 permanent residents who are under investigation for fraud related in most cases to residents. And unfortunately, the media has also reported that in some of these instances, there are consultants who have been involved and who have allegedly counseled applicants to falsely represent whether they were indeed meeting requirements for the purposes of citizenship. And under immigration legislation, there is a framework for the designation of a body to regulate citizenship consultants to designate immigration consultants to hold them to professional and ethical standards of conduct. And that authority is missing in citizenship legislation. And so the bill proposes to remedy that gap, to provide similar authority to hold citizenship consultants to ethical and professional standards of conduct as well.
Okay. I believe residency fraud is discussed before also. I'll ask you to inform us again if it is answered before. How many cases involved residency fraud? And if you want to give us some examples of ways people commit residency fraud.
The number, I believe, is 85 who have been found to be where there's been a revocation as a result of residency fraud. Residency fraud, it can take a variety of different fashions, but essentially it is people who are claiming to be in the country when in fact they are abroad. At the moment, without exit controls, we have no objective way of identifying this. We're often required to go through passports to look at stamps and so on. And starting next year, late next year, we will start to have more effective information about people's entry and exit into the country.
Well, can you also want to talk about some examples? Are those who try to hide their absences from Canada? I mean, some people try to hide their absence from Canada. I mean, how do they do it? Hide their absence from Canada. I mean, if they are gone somewhere, I understand that right now we don't have that entry-exit stamp.
So some of what has been reported as part of these large-scale investigations into residence fraud has to do with a fairly sophisticated pattern of fraud that unfortunately the department is seeing, whereby third parties are involved to help establish a fraudulent pattern of residence with real bank accounts and real phone records, but that are being used by someone else who's being paid to make withdrawals, or phone calls to establish a pattern of documentation to support a person's unfortunately fraudulent claim that they're here. We also have other circumstances where people have declared on their application that they're meeting and that they are physically present in Canada, or so they say, and we discover evidence after the fact, you know, whether it's through passport stamps, whether it's through entry-exit data from other countries, employment records from other countries, school records from other countries that show the opposite. And so this is the nature of the fraud that the department is seeing.
I'm sorry, unless Mr. Leung lets you go on, it's his turn.
Go ahead, Mr. Chair.
Thank you. Thank you, Mr. Chair. Let me now talk about one of my favorite topics. C-24 also provides the ability to strip citizenship from convicted terrorists who hold dual citizenship or deems an application for citizenship to be renounced. Can you tell the committee if you have done any comparative studies with other Western countries that have similar legislation? As my understanding is that virtually all Western democratic nations have this power, and for some of them, the requirement for revoking citizenship are far less stringent than what is being proposed in Bill C-24. Can you please comment on that? Thank you.
Yes, that's absolutely correct. Canada is one of the few countries, as part of our study, that we identified that don't have this ability to revoke that's proposed in C-24. For example, like-minded countries like Australia, the United States, the United Kingdom, and New Zealand all have such authority, as do most European countries that we looked at. And many of these countries have broader, less defined power than what is proposed in C-24.
Thank you, Mr. Chair. I wish to move back to a question of language requirement. One of them is that if the applicant has a speech impairment, is there exception in certain cases where the individual is allowed to do this by written exam, or is there a special dispensation for exemption on language?
So we certainly have now and would under C-24 have accommodations for persons who may experience different difficulties, whether it's a learning disability, whether it's a speech impairment, whether the individual may be deaf. Those people can self-identify now at the start of the process, and they do, and we will continue to take on board the comments of the committee and stakeholders in terms of best practices on any other things measures that we may need to look at in this area.
Now, is there, let's say for seniors, is there an age at which point there is an exemption, say at 54, 55, or whatever that age threshold is?
So under the bill, it would be the requirements for language and knowledge would apply to those up to the age of 64. So from 65 and up, they wouldn't apply.
They wouldn't apply. With respect to the language requirement of Bill C-24, how do we compare to other English-speaking jurisdictions, for example, like the UK, Australia, New Zealand, and the United States? I mean, are we comparable, or are we even more stringent?
Yes, that's quite right. In fact, the measures proposed in C-24 would make us more comparable with those like-minded countries. For example, the U.S. Requires those requirements to be met for up to age 65. For the UK, it's up to age 64.
And Australia?
Australia is 59.
Oh, okay. I asked this question previously, and I need to just get a feel what the technical aspect of it is regarding examples of the language level necessary to pass the citizenship test. For example, if a person comes in as a federal skilled worker and he's a psychiatrist, now obviously that level will require a much higher level threshold versus someone who comes in as a general laborer. Do we need, for the citizenship test, do we have a uniform level and then allow those special professions to be tested otherwise, or is that handled at the citizenship level?
So thank you for your question. So the level, you're quite right, for citizenship is uniform at CLB4, which is a basic language proficiency in English or French. However, as you mentioned, there are many who come in, skilled workers, with a significantly higher level. And I referred earlier to that list of acceptable evidence that applicants can provide for citizenship purposes. And that includes a test that a skilled worker may have already completed as part of their immigration process to Canada. They could reuse those results for the purposes of applying for citizenship because their level was already significantly higher coming in.
Thank you. Ms. Fitzpatrick.
Thank you, Mr. Chair. I would like to talk about people with temporary residency status. And so because under C-24, periods of residence with temporary residence status will no longer be applied toward the meeting of the physical presence requirement for naturalization to become Canadians. So looking at the higher numbers and growing numbers of international students who come to Canada and are tax-paying members of our society while they're students, usually because they're able to find work, and then usually they're lucky ones anyway, will find work as a temporary basis as they apply for permanent residence. And we're seeing growing trend towards a two-step migration process, especially with international students, where they first come as students or temporary and then transition into permanent residence. So what is the rationale for this change? So we're actually inviting students from all around the world to come here and then saying, well, the time you spend doesn't actually count. So what is the rationale behind that?
Mr. Chair, I think as the Minister explained earlier, the intent behind this is to look at that time as permanent residence as your time towards citizen. So the time that you have decided to become a permanent resident of Canada, that you have embarked on a journey that we hope will lead to citizenship, it's that time that you've made that decision to stay in Canada as a permanent resident that should count towards that time as citizenship. The numbers of international students, as the member has indicated, have been growing, but it's actually quite a small percentage of those students who stay in Canada. And I think in terms of the numbers that had the numbers of people who had applied some of their time as a temporary resident to their citizenship application, it's quite low. I think Mr. Art indicated this earlier. It's less than 15%. I think it's about 13%. The other point that I would make, too, is just on comparators with other countries. The U.S., for example, doesn't include any of your time as a temporary resident towards your citizenship. That would have to be permanent resident time as well, and that's consistent with some of our comparator countries.
Thank you. Switching gears again. On the idea, I may have understood the concept incorrectly, and if I did, I'd like the analyst or somebody to correct me, but C-24, individuals who have been accused of or charged, I think, in another country for committing certain crimes in their country, have maybe had a trial or without a trial been jailed for whatever reason in those countries, can now either, I don't remember which one it is, and somebody can correct me, it's either will be denied citizenship or can have Canadian citizenship revoked. My question is, it doesn't matter which one of those two it is. My question is about the fact that these individuals are being judged in Canada for what they may or may not have done in another country, and they may or may not have had a fair trial or have had due process, because I know many countries where individuals don't have due process. So my understanding is that one of our honorary Canadian citizens, Nelson Mandela, would not be able to be a Canadian citizen after C-24 passes because he was charged of, I think, terrorism or treason in his country and was jailed for that. So does that mean that he wouldn't be able to be a Canadian citizen? Like, I just want to know the rationale behind why we're, and who? Is it a Citizenship and Immigration Canada official, a bureaucrat, who would be given the task of being the judge and assessing if said country has due process and fair trials and making that decision? Is it going to be one CIC official who makes that decision on another country's judicial processes?
So I'll start with your last question first. In line with these other like-minded countries who already have these powers, it would be the minister who would decide, or a delegate if the minister decides to delegate that decision on revocation.
Right.
The minister did make the point earlier that for any overseas terrorism conviction where a 5-year sentence or more has been imposed, where the person is a dual citizen, which may give rise to revocation consideration, the department will have to do a 2-step equivalent process. So first of all, to check whether the foreign offence is equivalent to a Canadian Criminal Code offence. If it's not, then we wouldn't be proceeding. If it is equivalent, then the second part of the assessment would be done based on credible evidence available, and that would have to do with looking at, are there any concerns about the fairness of the process by which the conviction was achieved. So if there are concerns about the independence of the judiciary, about a political prosecution, that evidence would be before the decision maker, and they could make the reasonable decision not to proceed.
And the decision maker is the minister?
No, I'm sorry. We'll have to move on, Mr. Meningakis.
Thank you, Mr. Chair. And I want to go back a little bit to the decision-making process, the change in the decision-making process that the minister spoke about, going from a 3-step process to a 1-step process with respect to granting Canadian citizenship. Could you give us an idea of a percentage, a number of people that would be expedited by having their decision being made by a senior public servant as opposed to it having to go through the citizenship judge process?
So thank you for your question. We anticipate that if this bill passes, we would like to be in a position, and we're working to be in a position to implement the streamlined decision-making provisions of the bill at the earliest opportunity in order to benefit those significant number of cases in the backlog that the minister mentioned. And so under the measures proposed in the bill, it's anticipated that the vast majority of those cases in our backlogs would benefit from this new, more streamlined decision-making process. And so rather than going to a judge for decision, they would go to the increased number of officers who are being hired with some of the new monies that the department has received and who are being trained to complete this function. And I would invite my colleague, Mr. Orr, to add if I've missed anything.
No, just to add that I think that the impact is going to be very significant in terms of bringing down processing to under a year, estimated by 2015-16, with the new decision-maker model. And if, with the new money, if we kept the current system, we would be down only to 14 months by 2017-18. So I think that's on the chart that was distributed, but it gives you some indication of the very significant efficiencies that would be accrued through this, through C-24.
Thank you. I understand that with respect to the existing backlog. But going forward, what percentage of applicants do you think could be decided on by the public servant and not be referred to the citizenship judge? The citizenship judge will only be dealing with cases as far as whether there's a question as to the residency. Therefore, I would imagine that a significant percentage of people would be processed through the system by the public servants, so it wouldn't be referred there. Do you have a sense of how high that number can be? Roughly, I mean, I understand.
So we would anticipate that the great vast majority of applicants would be dealt with by a citizenship officer under this model that's proposed. And it may be in the order of a couple of thousand cases that the citizenship judge may need to look at on an annual basis because the officer on the face of the evidence that is there may not be satisfied that the residence requirement is met in that range.
Thank you. Do you have any concerns about the independence of public servants as decision makers, and will there be a training process for some people?
So citizenship officers are independent decision makers now, and they decide in the range of about 100,000 citizenship applications now that deal with certain matters, including proofs of citizenship, adoption cases, grants of citizenship to minors. So they already make those decisions guided by criteria under the law, as they would be under the measures proposed in the bill. And certainly they would have additional training to take on these new functions that are proposed in C-24.
I certainly could understand your previous comment that it'd be nice to implement it as soon as possible, because obviously it's going to be making life a lot easier for a lot of pretty much every MP in the House that deals with citizenship, and particularly citizenship and immigration issues. How does this practice, this new practice now, going from a three-step to one-step, compare with other countries, particularly our peer countries like the US, the UK, Australia, New Zealand?
It's more in line with what these other countries do. So Canada is the only country that has this three-step process, which results in the vast majority of applicants being accepted at the end of the day. And so most of those have a more streamlined process in line with what's being proposed in this bill.
Thank you. I have a question with respect to the discretionary grants of citizenship. And there's a. Am I taking somebody's time?
Mr. Opitz.
Oh, I'm sorry. You know what? I'll pass it on to you. No, I'm fine. Thank you.
Okay. We talked about people in the CF being given the opportunity to become citizens, but what about the folks like police officers and Crown servants? Is there a reason why they're not being included in this?
So the proposed measures in the bill are limited to permanent residents and individuals on exchange to recognize their extraordinary service to the country. It doesn't extend to others, but this is a function of the fact that when we did our homework and our comparative research on what other countries do, they offer in the U.S. and in Australia and New Zealand a fast track to individuals who work in their military only. And so Canada's proposed approach under C-24 is in line with what those comparator countries do.
So those are also folks, extends to folks, I think we talked about this earlier a little bit, but that are on attachment to the Canadian Forces, basically. So I know we don't want to be accused of poaching from other people's militaries, but definitely some people want to change where they live, and having served with, and that's one of the reasons my father came to Canada. He served alongside Canadians in the Second World War. Had to go somewhere because he couldn't go home, and he decided that those Canadians are pretty good guys. So that's one of the reasons he decided to make his new home Canada. So I guess those folks. So that's in line with all our allies. What they do with people that are on attachment to foreign serving militaries, if they state that they would like to remain in Canada, we would fast track that.
So the fast track for individuals working in the military is broadly in line with the allies, and the proposal under this bill C-24 to extend that not only to permanent residents but also to individuals on exchanges is the most closely aligned with what they do in the United States, where they don't require you to have permanent resident status in order to have the opportunity to be fast tracked for citizenship.
That's great. Costa, do you have anything else? That's it. Round's complete.
Ms. Sitza-Beeson has one brief question.
Oh, fantastic. I'm going to pass my time to Madame Blanchette Lamotte, because I know she has one. Go ahead.
Thank you. So I have a question for Madame Achsa. Comme je le comprends, dans le...
As I understand it in the bill, a person who has one citizenship only and is accused of terrorism will serve a sentence according to what the courts decide. However, a different person for the same charge of terrorism, if they have dual citizenship, would see their citizenship revoked and would be sent away from Canada. In your opinion, is this constitutional? Does that respect a person's rights? Because for the same sentence for the same crime, two Canadians could have two completely different sentences, rather. And I'm wondering, is it possible, in your opinion, that could be unconstitutional?
Of Justice Act, the Minister of Justice is required to examine bills that are to be presented to the House in order to ascertain whether or not they are inconsistent with the purposes or provisions of the Charter. And this examination process has taken place, and the bill wouldn't have been before you if the Minister of Justice had determined that the provision is inconsistent with the Charter. In terms of your question in particular, with regard to the revocation provision on the new grounds, which would apply to dual citizens only, it raises the question of Section 15 of the Charter, which protects individuals from discrimination on certain grounds. A Charter analysis is very contextual. A court will look at a non-exhaustive list of factors. Very important are the policy objectives behind the proposed provision. In this case, to reinforce the values of citizenship and to protect security and safety of Canadians. Now, the provision applies equally to all dual nationals, whether they were born in Canada or whether they were naturalized. The distinction is that between those who are dual nationals and those who have only Canadian citizenship. As you may know, Canada has ratified the Convention on the Reduction of Statelessness, and this convention prevents state parties to take away citizenship from a person if that would render them stateless. There are limited exceptions, for example, if citizenship was obtained by fraud. So it's by virtue of Canada abiding by its international obligations that this distinction is part of this provision.
Thank you very much, Mr. Orth and your colleagues. Thank you very much for appearing before us. It's been a big help. Thank you kindly. This meeting is adjourned.